as President of India, Justice V. Ramaswamy in his impeachment proceedings right up to Parliament, Shri P.V. Narasimha Rao, former Prime Minister of India, in the Lakhubai Pathak case, that is the pickle case, and the JMM bribery case. Some of the earliest judgments that he has, some of the earliest cases that he has appeared in before a constitutional bench of 5 judges in the Supreme Court is the case pertaining to the challenge to the amendment to the Land Acquisition Act 1894, in the case which is reported as Raghbir Singh versus Union of India. He is also an amicus curiae in many cases before the Honorable Supreme Court, some of which are the matter of interlinking of rivers in India, the case of R.D. Upadhyay, dealing with under trial prisoners in various jails, the plight of women and children, prisoners who are suffering from mental disorders. He has also been directed to head a committee of 3 advocate members to go to Bhopal and give a report as to the disbursement of compensation to the Bhopal gas victims. He was directed to visit the mosque and the mazar of Mirza Ghalib in connection with cleanliness and development in that area. He has been requested to assist the Constitution Bench in many matters. And he is presently assisting the Honorable Supreme Court for the betterment of Lord Sri Jagannath Temple in Puri, Orissa. I request the Honorable Keynote Speaker for today, Mr. Ranjit Kumar, to kindly address the gathering.
Good evening, everybody. Justice M.S. Sonak, Chairman of the Goa Legal Services Authority and a judge of this court. Justice Menezes, a judge of the High Court of Bombay at Goa. The Advocate General, Mr. Devi Das Pangam. Mr. Coelho Pereira, the President of the Bar Association. The office bearers of the Bar Association and the office bearers of the Legal Services Authority. I'm okay, but sound-wise it will be better. So otherwise my sound will go. Okay. That is why I just keep it. Put it like this.
Because they were saying it's coming.
Okay. So, the office bearers of the Legal Services Authority, senior advocates, former Law Minister Mr. Ramakant Khalap, colleagues and members of the bar, the professors and principals of the law colleges, the administrators, the students, ladies and gentlemen. You will pardon me if I am making a speech from a prepared speech and not making it extempore, because there are a lot of quotations which I will be reading. So please forgive me for that. Rule of law and constitutional values. I will preface it by just saying this, that our constitutional values are very much ingrained. If you look at the preamble of our Constitution, word by word, and you will find, and I'll give definitions to them later on in this evening, that each of those words will bring to you the values which our Constitution requires of us and which are ingrained in our Constitution. With that preface, the rule of law is a political ideal that all citizens and institutions within a country, state or community are accountable to the same laws, including lawmakers and leaders. Simply stated, no one is above the law. The term rule of law is closely related to constitutionalism. It refers to a political situation, not to a specific legal rule. The rule of law is defined in the Encyclopedia Britannica as, and I quote, the mechanism, process, institution, practice, or norm that supports the equality of all citizens before the law, secures a non-arbitrary form of government, and more generally prevents the arbitrary use of power. Unquote. Use of the phrase can be traced to the 16th century Britain. In the following century, the Scottish theologian Samuel Rutherford employed it in arguing against the divine right of kings. John Locke wrote that freedom in society means being subject only to laws written by a legislature that apply to everyone, with a person being otherwise free from both governmental and private restrictions on his liberty. The rule of law was further popularized in the 19th century by the British jurist A.V. Dicey. However, the principle, if not the phrase itself, was recognized by ancient thinkers. Aristotle wrote, "It is more proper that law should govern than any one of the citizens. Upon the same principle, if it is advantageous to place the supreme power in some particular persons, they should be appointed to be only guardians and the servants of the law." The rule of law implies that every person is subject to the law, including persons who are lawmakers, law enforcement officials, and honorable judges. John Locke also discussed this issue in his second treatise of the government in 1690, and I quote, "The natural liberty of a man is to be free from any superior power on earth, and not to be under the will or legislative authority of man, but to have only the law of nature for his rule. The liberty of man in a society is to be under no other legislative power but that established by consent in the Commonwealth, nor under the dominion of any will or restraint of any law, but what the legislature shall enact according to the trust put in it." Freedom then is not what Robert Filmer tells us, a liberty for everyone to do what he lists, to live as he pleases, and not to be tied by any laws, unquote. John Locke goes on to say, "But freedom of men under government is to have a standing rule, to live by, common to every one of that society, and made by the legislative power erected in it. A liberty to follow my own will in all things where the rules prescribes not, and not to be subject to the inconstant, uncertain, unknown, arbitrary will of another man, as freedom of nature is to be under no other restraint but the law of nature." Unquote. Although credit for popularizing the expression rule of law in modern times is usually given to Dicey, development of the legal concept can be traced through history to many ancient civilizations, including Greece, India, Mesopotamia, and Rome. The idea of rule of law is often regarded as a modern iteration of the ideas of ancient Greek philosophers who argued that the best form of government was the rule by the best men. Plato advocated a benevolent monarchy ruled by an idealized philosopher king who was above the law. Plato nevertheless hoped that the best men would be good at respecting established laws, explaining that, and I quote, "Where the law is subject to some other authority and has none of its own, the collapse of the state, in my view, is not far off. But if the law is the master of the government and the government is its slave, then the situation is full of promise and men enjoy all the blessings that the gods shower on a state." Unquote. More than Plato attempted to do, Aristotle flatly opposed letting the highest officials wield power beyond guarding and serving the laws. The Roman statesman Cicero is often cited as saying, roughly, within quote, "We are all servants of the laws in order to be free." Unquote. For us in India, the longest constitutional text in the history of the world has governed the country since 1950. Our constitution for us is intended to limit the opportunity for governmental discretion, and the judiciary uses judicial review to uphold the constitution, especially the fundamental rights. Although some people have criticized the Indian judiciary for its judicial activism, others believe such actions are needed to safeguard the rule of law based on the Constitution, as well as to preserve judicial independence, an important part of the basic structure doctrine. The Secretary General of the United Nations in 2019 defines the rule of law as, and I quote, a principle of governance in which all persons, institutions, and entities, public and private, including the state itself, are accountable to the laws that are publicly promulgated, equally enforced, and independently adjudicated, and which are consistent with the international human rights norms and standards. It requires, as well, measures to ensure adherence to the principle of supremacy of the law, equality before the law, accountability to the law, fairness in the application of the law, separation of powers, participation in decision making, legal certainty, avoidance of arbitrariness, and procedural and legal transparency. Unquote. The Council of the International Bar Association passed a resolution in the year 2009 endorsing a substantive definition of the rule of law, and I quote, an independent, impartial judiciary, the presumption of innocence, the right to fair and public trial without undue delay, a rational and proportionate approach to punishment, a strong and independent legal profession, strict protection of confidential communications between lawyers and clients, equality of all before the law. These are all fundamental principles of the rule of law. Accordingly, arbitrary arrests, secret trials, indefinite detention without trial, cruel or degrading treatment or punishment, intimidation or corruption in the electoral process are all unacceptable. The rule of law is the foundation of a civilized society. It establishes a transparent process, accessible and equal to all. It ensures adherence to the principles that both liberate and protect. The International Bar Association calls upon all countries to respect these fundamental principles. It also calls upon its members to speak out in support of the rule of law within their respective communities. Unquote. The constitutional values flow from the preamble of the Indian Constitution, which reads thus, and I am reminding all of you here, I am sure you have read it many times, what it reads like. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this the 26th day of November 1949, do hereby adopt, enact, and give ourselves this Constitution, 74 years to this day, one day short, if I may say. What does the preamble and its well thought out concepts, which I have just placed, like sovereignty, socialist, secular, democratic, republic, justice, liberty, equality, fraternity, signify? And I take each one of them and I present to you. Sovereignty. It declares India a sovereign, socialist, secular democratic republic. Being sovereign means having complete political freedom and being the supreme authority of itself. It implies that India is internally all-powerful and externally free. It is free to determine for itself without any external interference, either by any country or individual, and nobody is there within to challenge its authority. This feature of the sovereignty gives us dignity of existence as a nation in the international community. Though the Constitution does not specify where the sovereign authority lies, but a mention of, and I quote, "we the people of India," unquote, in the preamble clearly indicates that sovereignty rests with the people of India. This means that the constitutional authorities and organs of government derive their power only from the people. Socialist. We are aware that social and economic inequalities have been inherent in the Indian traditional society, which is why socialism has been made a constitutional value aimed at promoting social change and transformation to end all forms of inequalities. Our Constitution directs the governments and the people to ensure a planned and coordinated social development in all fields. It directs to prevent concentration of wealth and power in a few hands. The Constitution has specific provisions that deal with inequalities in fundamental rights and the directive principles of state policy, Part 3 and Part 4. Secular. We are all pleased when anyone says that India is home to almost all major religions in the world. In the context of this plurality, secularism is seen as a great constitutional value. Secularism implies that our country is not guided by any one religion or any religious considerations. The Indian state is not against religions. It allows all its citizens to profess, preach, and practice any religion they follow. At the same time, it ensures that the state does not have any religion of its own. Constitution strictly prohibits any discrimination on the ground of religion. Democratic. The preamble reflects democracy as a value. As a form of government, it derives its authority from the will of the people. The people elect the rulers of the country, and the elected representatives remain accountable to the people. The people of India then elect them to be a part of the government at different levels by a system of universal adult franchise, popularly known as one man, one vote. Democracy contributes to stability, continuous progress in the society, and it secures peaceful political change. It allows dissent and encourages tolerance. And more importantly, it is based on the principles of rule of law, inalienable rights of citizens, independence of judiciary, free and fair elections, and freedom of the press. Republic. India is not only a democratic nation, but it is also a republic. The most important symbol of being a republic is the office of the head of the state, that is the president, who is elected and who is not selected on the basis of heredity, as is found in a system with monarchy. The value strengthens and substantiates democracy, where every citizen of India is equally eligible to be elected as the head of the state. Political equality is the message of this provision. Justice. Justice ensures that freedom of one does not become the tyranny of the other. The justice to be truly meaningful needs sharing of power, compassion towards underprivileged, and empathy towards the disadvantaged. An education of rights and duties becomes important to ensure to fight justice. Liberty. Liberty of thought and action is a fundamental value embedded in our Constitution. It is the basis for creativity and exploration of new ideas and experiments that can advance social progress. Respecting the rights of others to liberty of thought and action are hallmarks of a civilized society. Ensuring that this liberty of thought and action is not used to belittle or diminish the beliefs and status of others is what constitutes a decent society. Democracy creates opportunity to pursue one's chosen ends as well as respects others' rights to do so. In a diverse country like India, exercising freedom with responsibility is a must for ensuring peace in the nation. Equality. Equality is another value enshrined in the Constitution. Freedom and justice remain mere words if equality is not ensured. It implies freedom from exploitation and ensuring to provide opportunities for individuals' development, irrespective of the background, gender, cultural or socio-economic identity and status. Fraternity. Fraternity is at the heart of the school, society and the nation. Social solidarity is a vital part of a society that has place for the aspirations of all members of the society. Understanding the importance of fraternity or solidarity and the knowledge that we are all belong to a large community, a nation, and the globe is also to discover our innate humanity. It is only if we recognize our interdependence when we empower to help build a peaceful nation and a world. The citizens need to internalize the principles of equality, justice, and liberty to promote fraternity among all, regardless of religious beliefs, regional and local diversity. As the Constitution encompasses the values for living in harmony with self and one's natural and social environment, it provides the baseline in working out the framework of values to be nurtured in its students. If values like truthfulness, sense of responsibility, trustworthiness, loyalty, love, peace, respect for others are nurtured in us right from the beginning of the school, the efforts will go a long way to enable students to abide by the Constitution and contribute to larger health of the society and nation at large. In fact, promoting values at the school or societal level begins with the individual in relation to the community, larger society, nation, and the world. The dignity of the individual. Promotion of fraternity is essential to realize the dignity of the individual. It is essential to secure the dignity of every individual, without which democracy cannot function. It ensures equal participation of every individual in all the processes of democratic governance. Apart from constitutional values as enshrined in the preamble, as explained herein above, these constitutional values can be shortly put as constitutional principles, constitutional identity, constitutional morality, constitutional objectivity, constitutional goals, constitutional trust, constitutional governance, constitutional culture, and constitutional ethos. Therefore, I have tried to amplify the above values by referring to in detail to each of the concepts in the preamble. As described by the Supreme Court in the practice of sati in the case of Navtej Singh Johar, the search for constitutional values is a complex quest. The quest becomes even more complex when the Constitution is transformational. A transformational Constitution is aspirational and therefore futuristic and endeavors to transform the society from its parent state in accordance with the constitutional prescription. The identity of the Constitution of India as a secular state is also a transformational prescription. In India, secularism has been a tool for nation building after the success of the anti-colonial movement to bring together the diverse groups in Indian society. The promise of the secular nature of the Indian state was extraordinary as an idea of nation building, and its moral appeal was certainly higher compared to the notions that are developed in our neighbors' countries. Karl Clare describes transformative constitutionalism in the context of the South African Constitution in the following words, and I quote, "By transformative constitutionalism, I mean long-term project of constitutional enactment, interpretation, and enforcement committed to transforming a country's political and social institutions and power relations in a democracy, participatory and egalitarian direction. Transformative constitutionalism connotes an enterprise introducing large-scale social change through a non-violent political process grounded in law. I have in mind a transformation vast enough to be inadequately captured by the phrase reform, but something short of different from revolution in any traditional sense of the word." According to Gary Jefferson Jacobson, constitutional identity represents a mix of aspirations and commitments expressive of a nation's past. It also evolves in ongoing political and interpretive activities occurring in courts, legislature, and other public and private domains. Unquote. Gautam Bhatia discusses the transformative constitution as one that is consciously, I quote, that is consciously designed to transform not merely the existing legal and political system, but also the social and cultural structures that often undergird the law and the politics of a society. Unquote. After 74 years of the commencement of the Constitution, certainly the conscious design by the framers must not be the only lens to examine India's constitutional identity. Its interpretation, enforcement, and evolution, both by the legislature and the courts, to understand its political and legal interpretation of the conscious design must be factored into to comprehend the constitutional identity as has been advocated by Clare and Jacobson. Secularism is one such constitutional identity of the Indian Constitution. In M. Nagaraj, the Constitution bench of the Supreme Court, speaking through Justice Kapadia, as his lordship then was, in the context of reservation, has said, and I quote, "It is a fallacy to regard fundamental rights as a gift from the state to its citizens. Individuals possess basic human rights independently of any constitution by reason of the basic fact that they are members of the human race. These fundamental rights are important as they possess intrinsic value. Part 3 of the Constitution does not confer fundamental rights. It confirms their existence and gives them protection. Its purpose is to withdraw certain subjects from the area of political controversy, to place them beyond the reach of the majorities and officials, and to establish them as legal principles to be applied by the courts. Every right has a content. Every foundational value is put in Part 3 as a fundamental right, as it has intrinsic value. The converse does not apply. A right becomes a fundamental right because it has a foundational value. Apart from the principles, one has also to see the structure of the article in which the fundamental value is incorporated. Fundamental right is a limitation on the power of the state. A constitution, and in particular that of it which protects and which entrenches fundamental rights and freedoms to which all persons in the state are to be entitled, is to be given a generous and purposive construction. Justice Kapadia goes on to say, the expression life in Article 21 does not connote merely physical or animal existence. The right to life includes the right to live with human dignity. This court has in numerous cases deduced fundamental features which are not specifically mentioned in Part 3 on the principle that certain unarticulated rights are implicit in the enumerated guarantees. For example, freedom of information has been held to be implicit in the guarantee of freedom of speech and expression. In India, till recently, there was no legislation securing freedom of information. However, this court, by a liberal interpretation, deduced the right to know and right to access information on the reasoning that the concept of an open government is the direct result from the right to know, which is implicit in the right of freedom of speech and expression guaranteed under Article 19(1)(a). He further goes on to say, the important point to be noted is that the content of the right is defined by the courts. The final word on the content of the right is of this court. We may have a look at common constitutional provisions under the German law, which deals with rights such as freedom of press or religion, which are not mere values. They are justiciable and capable of interpretation. The values impose a positive duty on the state to ensure their attainment as far as practicable. The rights, liberties, and freedoms of the individual are not only to be protected by the state, they should be facilitated by it. They are to be informed, overarching and informing of these rights. Overreaching and informing of these rights and values is the principle of human dignity under the German Basic Law. Similarly, secularism is the principle which is the overarching principle of several rights and values under the Indian Constitution. Therefore, axioms like secularism, democracy, reasonableness, social justice, etc. are overarching principles which provide linking factor for the principle of fundamental rights like Article 3, 14, 19 and 21. These principles are beyond the amending power of Parliament. They pervade all enacted laws and they stand at the pinnacle of the hierarchy of constitutional values. Justice Kapadia goes on to say, secularism in India has acted as a balance between socio-economic reforms, which limits religious options and communal developments. The main object behind the theory of the constitutional identity is continuity, and within that continuity of identity, changes are admissible depending on the situation and the circumstances of the day. Lastly, constitutionalism is about limits